Welcome to City Corner, an ongoing program where we talk with council and city staff about what's happening in our city. Hello, I'm Hollie Logan, and today we have brought on the program Development Services Manager Rick Simon and Hearing Examiner Gary McLean to talk about the role of the hearing examiner and how it has improved the city's development review process. Welcome, gentlemen. Thanks for being here today.
Thank you.
Rick, let's start with you. The city has used the hearing examiner process for the past 2 years. Prior to that, land use hearings were conducted through the Planning Commission. Why did the city change the process, and how has it benefited the city's administrative hearing and appeal process?
Well, the city took a look at what's happening across the Northwest, and throughout the state of Washington, a lot of communities have gone to a hearing examiner system, and that is largely a result of increasing complexity in the land use process and a lot of very expensive lawsuits when cities make mistakes. And we found that communities that do go to the hearing examiner system tend to have decisions that are upheld in court and result in reduced liability for the city. So while our particular planning commission didn't have any problems, we felt it was still the best direction to go for the city into the future.
Okay, great. So how specifically is this procedure different from the previous Planning Commission hearings?
Well, in terms of the procedure itself, it's really the same. I mean, the permits that require public hearings, instead of being held in front of the Planning Commission, are now held in front of the hearing examiner, but we do have the same number of hearings, same type. Same notice is provided for all the hearings, so from a procedural standpoint, it's really very similar.
Okay, great. So Gary, can you explain how the hearings are conducted exactly?
Well, the process always begins with the initiation of an application that's come in, obviously, and then the week or so before the hearing, sometimes 2 weeks, sometimes sooner. And folks at home can find the same stuff. The staff posts the staff report, which summarizes their review process. Mm-hmm. And let's say there was an environmental analysis, there might have been substantial community input in the form of letters, and maybe they hired experts to comment on some aspect of the proposal. And all of those things are generally analyzed in the staff report, which is a neutral assessment of what's happened, but they're also, under the city's code, required to make a recommendation. And even where they recommend yes, they often have conditions. So it's yes, but here's this. And sometimes the applicant themselves submit challenges or questions or objections to, let's say, conditions. And so all of that is generally included in a staff report with a number of exhibits that happens the week or two before. And again, it's posted on the website so folks can look at it. So I have to review those. And then here within the city, we do site visits to sort of see what is the neighborhood, or in the context, where is this vacant land? Where's the river? Where's the water flow? Where's the light? Where's the shadowing going to be? You look for transportation things related to the site visit. I look at that, and that can be part of the decision because it's important to have an understanding of the context of where something is. But in addition, then you move into the public hearing process. If I've seen the site or if I go see it later, it really brings the comments of the public and other people to life.
Sure.
It's sort of like, I understand when you tell me you live 3 doors down from something. Oh, you really do. So when you tell me you're concerned about dust or something like that, I get it. I see where you are in the context of the application. Then during the hearing process, when that comes forward, it's often you have the representatives of the applicant team, you have the city development review staff team, and it depends on the nature of the application. You could have more staff members present or fewer depending on what type of application. And the same with the applicant team. It could be a very complicated project. They might have a lot of experts. They have the right to be represented by attorneys. All sides do. In some jurisdictions I'd have to tell you, I can only count on one hand where an applicant is not represented by counsel. In Richland, generally speaking, people are not, but they can be, because the stakes are so high nowadays in development processes. So then you open the process. I let everybody know one thing I do. I'm not sure it was done before. Everybody's under oath. because under the law I'm required to accept what you say as the truth, but if you're going to tell me the truth, you need to swear or affirm that that's what you're doing, put yourself under oath. And staff makes a presentation, the applicant makes a presentation, members of the public are then invited to speak, testify if they have experts and things of that sort. Then the two teams are given an opportunity to respond at their peril. I always say it that way, because sometimes the applicant doesn't want to respond, and they don't have to. And sometimes city staff chooses not to address a particular statement somebody in the public might have made because it may not be relevant. It may be on a totally different issue. There may be payback, there may be game playing going, I don't know, but that's up to the applicant team, that's up to city staff team. And then I have to take everything away and go back to my office and consider it. And there may be post-hearing briefs, there may be post-hearing submittals, and consider it all and then issue a written decision, which is transmitted to the city, and then it's posted on your website.
It is.
So that's sort of, a general description.
Right,
And it really depends on the nature of the application, but most all of them involve that process.
It sounds a little bit more like a courtroom setting in a way, but
Well, it is, but it's not as formal. And I say that because I don't want people to be scared away from coming.
Sure.
They shouldn't be. But why is it like that? Because if somebody appeals it, and I said the stakes are high, they really are. In the state of Washington now on development, there's less land available.
Right.
And what land is available is more expensive. It costs more to develop on it. And it really costs a lot for an applicant to put together an application because the state legislature has said so, that a lot of things have to be reviewed before you get to the application phase. And Rick and his colleagues and city staff, there's a lot of very technical information they have to review. And so when somebody's in front of a hearing examiner or a body asking for a permit to be approved, they're not there just for kicks and giggles. They're there because it's really important to them. And then on the flip of that is the public too. They have legitimate concerns to express, and in all fairness to them, you really have to have a process so you can level the playing field for everybody. And you explain the rules, everybody's playing by the same rules, so then they all have the opportunity to make fair input and then have a fair decision is the hope. But it is less formal. But I want to caution folks on there because you can't speak from anywhere in the room. It's not just a free-for-all.
Right.
Because an official record is being made. And if I make a mistake and a court wants to overturn something I've done or the city council, it's based on that record that happens during that hearing that night. And judges and court clerks, they listen to those tapes.
Right.
So you really have to make sure people understand what the rules are and they speak one at a time.
Let's set those boundaries and
As best you
hope
can.
they stick to them.
and I'd say 9 times out of 10 people do. And let me give you an example. A lot of times members of the public, they police themselves better than a hearing examiner or anybody can. And I had a hearing in one jurisdiction, about 30 people in a room. And one individual decided to sort of hog the floor, wanted to talk all the time and didn't want to give everybody else a chance. And members of the audience were rolling their eyes. They weren't booing or hissing because that's not permitted, but you could see they were getting frustrated. And I've implemented a rule where everybody speaks once for a certain time period, and then other people get a chance to speak, but you don't get to speak for an unlimited time period. And if you want to speak again, you get to the back of the line when your time's up, 3 minutes, 5 minutes, whatever.
Sure.
And folks that weren't getting to talk, they appreciated that because they needed to get on and do something.
Sure.
Yeah, but they wanted their turn.
Well, yes, that makes sense. And as a hearing examiner, you just mentioned how you attempt to keep the process fair and factual. So what are some of the other things? You set those parameters early on in the meeting, every meeting?
I try to remember to tell folks, here's the format we're going to follow. Because most of the members of the public that are present have never been to a hearing. And so I try to lay out what the process is going to be, and it's usually the same. And I just let folks know this is your part, and this is when you come forward, and this is when they're going to answer questions or not. And if you have an understanding of what the rules are, I think people hopefully feel like they had a fairer opportunity to be heard. And at the beginning, if people have questions, if they're fair, or if they're reasonable, I'll let somebody ask, like, are you going to have a time limit? And I'll look around. I say, everybody who wants to talk, raise your hand. And if 5 people raise their hand, I doubt I'm going to have a time limit.
Right.
But if 40 people raise their hand, I'm probably going to have a time limit.
That makes sense. So can you tell us what experiences, training, or background, and especially for yourself, do you draw on most as it relates to your decision-making process?
Well, I try to think of myself in the shoes of every person that's talking to me, because I do have to say, with my background and experience, personal and professional, I've been in every chair. I'm an attorney, and I've been a member of the Washington Bar since 1989. And I started out in a very big law firm, and we did a lot of work on governmental relations and environmental law on a national scale. And then I started to move into governmental relations on the local government level, and I served as a city attorney for a couple of jurisdictions in the state. And I've been a city manager for a medium-sized city in the state. And then in private practice, where I've been now, I'm the hearing examiner for a number of jurisdictions in the state. But I also, in my private practice, I've represented people. Sometimes they're in the neighborhood and they're asking for certain things on a project. And on the other hand, I've represented landowners who wanted the jurisdiction to be fair with them. So I know what it's like to be in each of those seats. And hey, I live in the state, I'm a citizen, I'm a homeowner, and I've had occasions where I've needed to make comment on projects too. So anybody that's talking to me is the most important person in the room when they're talking to me. And I try to think, how did I feel when I was in that position when they're there in front of me? And I honestly try to apply that as I'm listening to them. So if I hear somebody grumbling or groaning or rustling paper or making noises while somebody who has a very soft voice is talking, that's rude. And I'll ask the room to stop. And I'll give that person more time to collect their thoughts and things of that sort. And similarly, if an applicant isn't prepared or somebody didn't come, all right, if they reasonably say, can I please call my engineer or something like that, hey, I'll listen to that. That's fair. And on city staff side, I know they might get, figuratively, members of the audience might be really angry about something that happened earlier in the week at the city council meeting. But the people in front of me, they're not the staff people that's about. And it's like, hold on, here's what we're here for. We're talking about this project, not something that happened 6 weeks ago.
Where we don't have a lot of context to what it is that you're talking
so,
about, right?
So basically, because I've been in those different positions, I try to think, how would I feel if something went that way or didn't go that way? And I think that helps.
Sure.
I think it does.
Yeah, I'm sure it does. One more for you, and then we'll move on to Rick. Explain how you develop the record for your decisions.
Well, the city council decides what the code is and what the rules are. And that's one thing people need to understand, is that for a subdivision, there are a certain set of rules. And under state law, the applicant has the burden of proof to meet all these rules. And if it's like a track meet, there are hurdles that you have to jump and run around the track. Just because there's nobody in the room that night doesn't mean that I lay down all the hurdles. That would be unfair, because the city code says they have to jump over these hurdles. In other words, prove you won't kill birds or this, that, and the other, whatever the code says. It's my obligation as the hearing examiner to make sure that those hurdles are up and that they are jumping over all of them in order for me to get to a yes. And so if some activist group is there and they're there to make sure everybody's dotted their I's and crossing their T's, it's less likely that the examiner needs to pose a lot of questions, because the record is being developed in the form of testimony and things of that sort. But where subjects are missed, let's say there's five issues, and everybody talks about 3 issues. Well, the burden's on me then to make sure the other 2 are met. And so I will ask questions about those things, because like I said, like the track meet, you got to make it over those hurdles.
Right.
And if you don't, I can't write a decision. And if I don't feel the record is complete on a certain topic, it's rare, but I might say, hey, I've still got a question about this. Do you all want more time to write something about it, or does your engineer need to write a response because this neighborhood person brought in a piece of evidence that's very important? And it really depends on what you see, but I see that as the obligation is for the hearing examiner. You got to make sure that all the rules are applied to everybody all the time, no matter how thorough or how substantive the testimony is or not. It's your role to ask the questions to make sure the applicant and the record are complete.
Sure. Good. So Rick, how has the change to the hearing examiner process aided staff in the quasi-judicial matters?
Well, one thing that it's done for us is it's kind of simplified our process as we approach a hearing. When we had the Planning Commission, one of the things that really was easy to get tripped up on were things like conflict of interest and appearance of fairness. And when you have a 7 or 9 member body, there's lots of potential for an appearance of fairness issue to crop up. And so oftentimes our commissioners would be calling us and saying, well, so, this organization apparently is going to, present testimony, and I'm a member of this organization. Can I participate in the hearing or not? And we'd have to seek oftentimes counsel from the city attorney. And now with the hearing examiner system in place, all of those issues have gone away to a very large degree.
So then what are the responsibilities that the Planning Commission are able to focus on now that the hearing examiner has taken some of those legal decisions on land use and permitting?
Sure. So the commission is now focused entirely on legislative issues. And in the past, they split their time between the quasi-judicial and legislative. So things like comprehensive plan updates, they're currently, as we go through our update process, they're spending a lot of time on that. They review all of our code amendments when we make changes to the development regulations. They look at things like the Transportation Improvement Program. They serve as the advisory body for the Community Development Block Grant funding allocations. So they still have a very important position within the city.
They still have plenty to do. That
Yes,
sounds
they do.
like it for sure. Great. So Gary, if you will, what is the process if someone disagrees with your decision?
In the city of Richland, the code is currently written where most of the decisions the hearing examiner makes are subject to appeal, if you want, to the city council.
Okay.
I think there may be one type of hearing that goes directly to Superior Court, but I think right now all of the ones I've issued are appealable to the city council. And in the context of a subdivision, that's a recommendation, that's not a decision. And so under the law, they asked me to write the recommendation and say these are the conditions that should be imposed, and then it goes to the city council. They don't have to receive new testimony and things. Under state law, there's only one open record public hearing, and that's what's been delegated to the hearing examiner's office. And so we do that, or I do that, and I try to make sure the record is as fully developed as possible. So if they're seeing people come in and say they really don't like this project, I want you to kill this project, somebody asks them to do that, the council then has a thorough record to look at to decide, well, did they check all the boxes or not? And my job is to try and make it easier for them to make a decision. And if it ever had to go to Superior Court, that's a land use petition appeal. But in the city of Richland, most all of them go to the city council. There haven't been any, and I think all the subdivisions have been approved.
That's right.
But the hearing examiner here, I issue special use permits, which in a lot of jurisdictions is called a conditional use permit. And those, if you want to appeal a decision issuing that or denying it, that would go to the city council. Yeah.
So unless there's an appeal, if you make a recommendation, it's moved forward, or does the council have to then approve it?
Well, it is ultimately the council's decision, but to date, they have, I think, in every case, have adopted the hearing examiner's recommendation, which makes good sense because he's developed a very full record.
Right, as you said, a complete record, so they have all of the information.
Right.
Okay. So how have citizens responded to the hearing examiner process as it relates to these quasi-judicial matters?
Well, I'm sure that's different for every citizen that comes to a hearing, but from my perspective, I think the citizens have responded, pretty favorably to it. Gary does a great job of sort of setting the ground rules and making sure everybody has a chance to speak their mind. And I think they go away from the hearing feeling like they've been heard. And so I think that's a very positive circumstance, and I think probably those hearings are a little bit run maybe a little bit more professionally than they have been in the past.
Mm-hmm. That speaks a lot to Gary and his experience and
Yes.
and how that operates. And from your perspective, how is the city doing in developing an impartial and legal record of these quasi-judicial matters?
I really have to credit staff with putting together good staff reports and the analysis that is conducted beforehand. And because I get it beforehand, for instance, if I see a report, and it's not here, and it hasn't happened here, but just as an example, if there's an expert report that's very important, and I've got a lot of public comments saying, I love that report, or I hate that report, or I've got questions about that report, I have the ability to contact Rick as my contact point with cities. And so just on an administrative basis, I might say, I think it would be helpful if that expert's there, because I've got questions for him. And I'm sure members of the public are going to ask about the report or something. So that helps the record be more fully developed, as opposed to they're not there, it's just a piece of paper talking. And they're unable to clarify, and it might shorten the process too, because it may be that it's something we have to extend it and get an answer in writing if we don't get an answer in person. And the fairness issue in developing the record thoroughly, back to your question, members of the public that speak, I've had it happen here, the citizenry here in Richland, very well informed, highly skilled, great attention to detail.
Passionate,
they read the material.
They're passionate, yeah.
I mean, people have been in front of me, and I commend them all the time, and it's true. And it's on TV. And they can watch one and educate themselves if they've never been to one about, well, this is how it went 2 or 3 times before, so I'm going to go and I need to be prepared. And I don't know these people. I haven't met them, and Rick was saying one thing, conflicts of interest. I don't have clients over here, so I'm not in conflicts with people and things of that sort. So it's a level playing field in my mind. I don't know that she owns 500 acres and he cleans her windows. I don't know that.
Right.
They're regular people in front of me.
You really are focused on the facts and the records.
And and to keep it fair, if somebody comes in front of me and tells me that they know that this building is going to cast a shadow on their property and yakety yakety yak, I'll ask them, how do you know that? Did you measure that? And how do I know that what you did was accurate? And if you're a humble person, you're unlikely to tell me, well, I'm a rocket scientist. Well, you know what? You need to tell me that. You need to tell me that you're an engineer and that you know how to draw this and that you have an expertise in this field. Because if that's what you're speaking about and you want your testimony to have more weight, tell me why you're right. And because that's what city staff does when the public works director says, I'm a professional engineer and I know about street designs, and the applicant people, I'm a wildlife biologist. Trust me, I know about wetlands. So members of the public that come forward, it helps when they tell me, hey, I'm Susie Citizen, but you know what? I'm also an expert in this field, and I've done some study on this, and here's what I want you to know. That helps. And guess what? That happens here in Richland. You get great citizen experts on issues, which hey, that creates a thorough record.
Okay, great. Well, I think that's a good place to end this program. I'd like to take a moment and thank my guests, Rick Simon and Gary McLean, for talking with us today. The hearing examiner meetings are usually the 4th Thursday of the month and air on Richland City View 192 and are available for replay from the city's website. If you have any questions about the hearing examiner process or anything about your city, the best place to start is the city's website. Thanks for watching this edition of City Corner. I'm Hollie Logan.